Facebook recently paid $16 billion for WhatsApp, a company that had barely made a profit. Where's the value in that transaction? Well, like with many transactions in the IT sector in recent years, the value is in the personal data. The data about individuals, what you might buy, what you're thinking of buying, is all important. Big data has become the new currency for businesses, and arguably it will define the success of one business over another. Now, many of the big data processes for targeting people with products and services rely on so-called anonymous profiles of data. So no one needs to know precisely who you are to know that you're a man in their 40s interested in a BMW. Your identity is not relevant for that advertisement. But increasingly, in the age of big data, there is more and more data, more and more computing power to throw at that data, and privacy advocates say that your identity is never going to be protected if you throw enough computing power at that data. So big data assets come with a lot of privacy obligations. So what are the privacy implications of big data assets in Australia? Well, if you're a company with a turnover of more than $3 million, if you trade in Australia, you have obligations under the Privacy Act. There were major changes for the Privacy Act in Australia in March of 2014. Those changes include the ability of the Privacy Commissioner to conduct audits, to investigate complaints, and ultimately to have fines of up to $1.7 million for breaches. At the point of collection of personal information, companies are now required to notify individuals that information is being collected. Well, what is personal information? Is it just someone's name, bank account number or email address? Or is it the so-called anonymous profile of information stored about a consumer in a behavioural targeting model? Well, given the increased power of computers to use that data and triangulate with other data sets, most information which is collected about an individual should be treated as personal information. And if you don't treat it as personal information, companies are exposed to risk. The other thing companies need to do with personal information is take appropriate steps to secure that information. And that includes an ongoing and continuous approach to security systems, perimeter controls, stopping unlawful access to data. Many of these privacy obligations, which are now much more serious obligations under Australian law, require the ongoing activity of companies to make sure they maintain continuous vigilance and compliance. These are all very important for the new asset class of big data. The cost of a data breach can be measured in reputational damage to companies, which is hard to fathom once you've lost the trust of your consumers. Also, there is the cost of a cleanup, the very real cost, and in the US there are many recent examples where that cost has extended to millions of dollars. Finally, the CEO of Target in the US has recently lost his job for theft of company information, continuing to add to a list of high-level executives who are losing their job for not having privacy and information security adequately dealt with within their companies. I'm Vincent. Thank you for your time.